This is in the District Court of Ellis County, Kansas. Case number 20 DM 128. Ivy Agnew and Roger Agnew. May I have an announcement of appearances, please?
Honor Colton Eikenberry of Hayes appearing as counsel of record for Ivy Agnew.
Your Honor, Roger Agnew appearing pro se.
Ivy Agnew appearing.
Yes. Okay, we had continued from the last hearing. We had Mr. Agnew's motion for contempt. Are you wanting to pursue that yet, Mr. Agnew?
I am, Your Honor, but I think we have some other things we have to address prior to getting to that point.
Okay. What is that?
We still have the issue about Ms. Agnew's counsel, and so without having resolved that, I don't know if we can coherently continue to argue the contempt issue.
Okay. There's also an issue regarding your income withholding order.
Yes, Your Honor.
And have you been making your child support payments?
I have not made any payments at this time.
Why not?
I need the new order, Your Honor.
Well, you don't need an income withholding order. That's put in place to help you, but your obligation is to make your payments.
Understood, Your Honor.
You need to be making your payments. You don't have to wait for the income withholding order. Okay? Okay, on the issue of counsel, Ms. Agnew, you filed a motion to represent yourself pro se. At the time we had the hearing to allow you and the children to move to Bulgaria, it was with the clear understanding of the court that you would still have a local counsel that Mr. Agnew and or the court could work through, because it's very difficult, almost impossible to serve you with things in Bulgaria. You need local counsel so that this can be dealt with. The issues that pop up need to be dealt with. Okay? And you assured the court that you'd have the financial wherewithal with your new job to have counsel. What has changed?
So my residency took longer to get approved through the Bulgarian government. They're a little bit slower. So that isn't actually coming until next week. Until that comes in, I'm not able to legally work. So I've had to live these last 3 months off of our savings and make all of this work on top of us not receiving child support in over a year. Our finances are strained. I will be able to begin work very soon, but thus far I have not been able to gain any revenue. I also, when I reread it, I had thought that outlined that I needed it to complete the income withholding order. And I was not aware that I needed to retain counsel for the next 12 years. I have tried, and I can continue to try to find alternative counsel. Thus far, the responses we've gotten are, we won't take the case, the international case, or they want retainers that I can't afford at this moment.
Mr. Eikenberry.
Honor, I guess I should give the court a little bit of background about what has transpired without going too far and breaking any kind of attorney-client privilege. But I provided a child support worksheet to my client January 3, and the next and only correspondence I ever got back was that she was not going to use my services any longer and wanted to end our attorney-client relationship. She advised she was upset that I had actually had communication with Mr. Agnew after that point. Since that day, we have had absolutely no correspondence from Ms. Agnew. And I would simply state, Your Honor, that our attorney-client relationship is broken and completed as per my client's instruction. So I really am not serving any purpose any longer here, as we are not communicating.
And Miss Agnew, and I know you've remarried. What is your new name?
I still have Agnew as my legal last name for legal documents.
Miss Agnew, you understand you need to have local counsel. Okay, that was a requirement of allowing you and the children to go to Bulgaria. Okay. What I'm going to do at this point is place you and Mr. Eikenberry in a breakout room and let you talk and see if you can resolve this issue. Okay,
Okay.
so Jess, if you would put Mr. Eikenberry and Miss Agnew in a breakout room. Okay. Miss Ivy, you've had time to talk with Mr. Eikenberry in the breakout room.
Yes, Your Honor.
Okay. Have you resolved any differences?
Yes.
Okay, Mr. Eikenberry.
Yes, Your Honor, I believe so, and like to go forward with the first issue that you brought up regarding the child support. And as Ms. Agnew stated, she is in a very bad financial place right now, and it's chiefly due to Mr. Agnew not making any child support payments for a very long time. I think we're talking about probably 13 months worth, where no payment at all has been received for the support of the children. And as she stated earlier, she's going to be able to begin working next week. So her situation will be helped a little bit by that, but primarily we need to ask the court to order Mr. Agnew to make a payment, whether there's an income withholding order in place or not. And as related to that portion of it, I had been notified that I was being terminated as counsel before the process could even begin for that. I did send a child support worksheet to my client, but she lost access to her email after the move. And then the next thing was her letter terminating me. So we are willing to go forward with me representing her, with the promise that she will begin making payments toward my outstanding bill after she reviews it again. But we are certainly not, I'm certainly not ready to argue any of the outstanding issues today. As the court said last time, I was not ordered to prepare or do anything, but that I would remain in the case until the next hearing. And here we are, Judge. So that would be our request now, for the court to make an order that Mr. Agnew send a payment to the Kansas Payment Center. And I would suggest $1,500 within a week. And that would cover the current support due for the month of April, and would begin working toward his arrearage, which is going to be in excess of $10,000. I believe it was $8,000 when we had the trial on this.
Mr. Agnew.
Yes, Your Honor. I put in the motion to compel the income withholding order. Ms. Agnew had made it very clear that Mr. Eikenberry already had the completed order done. Honestly, if that's the case, if we have it done, then as soon as I get it, which should be today, if he's got it and it's compelled, then I can have that turned in and payments start coming out as soon as next week, because that's my next paycheck. I've got my entire payroll department already aware of the situation, ready to go and get it done and taken care of. I can make a payment. I can't make a $1,500 payment right now. I don't have that kind of cash laying around. I just don't. So I can make the standard payment that would have been due last week at this point, and I can make that. That's not a problem. But again, this is all in regards to the fact that the IWO hasn't been submitted. I've been waiting simply to make sure that the correct stuff was being pulled out the correct way at the correct time. And as I've mentioned before, and I'm going to maintain it with the understanding that it's not the way that you would do it, Your Honor, but it's important to me to make sure things are being done correctly and timely. And as I've made arguments in the past, none of this is stuff that I have any control over. I'm just simply the one making.
Mr. Agnew, I need to cut you off. One, I've got another hearing starting in a few minutes. Two, the allegation is you have not made a child support payment in a year. With or without an income withholding order, your obligation is to make your payment every month. You can make that payment without an income withholding order. And that's your obligation. Have you not paid in a year?
If that's what the record shows, that's. But again, if we go back to what was said at trial, I thought that everything was being paid and taken care of because I was receiving nothing different than that. And so once I found out
Mr. Agnew, it is your responsibility to make sure your child support is being paid. You check your pay stub, you can see whether they're withholding money or not. You need to make a substantial payment. Okay. Now, Miss Ivy has filed a motion pro se that Mr. Eikenberry will need to review with her, and we'll need to set a hearing. So Jess, we need to set up a hearing, hopefully in about 10 days to 2 weeks, because we have some significant issues to deal with. You better give us about 90 minutes.
Your Honor, that motion also needs to be sealed. It's got the children's names in it.
Judge, on the 28th, you could start at 10 a.m.
Mr. Eikenberry?
My calendar's open that day, Your Honor.
Mr. Agnew, April 28th at 10 a.m.
I can make that, Your Honor.
Okay, Miss Agnew.
Yes, Your Honor.
Okay, Jess, set us down for 90 minutes on April 28th, 10 a.m. In the meantime, Mr. Agnew, you need to get a substantial payment in. Okay?
Understood, Your Honor.
It is not an acceptable excuse to say I was waiting for the other side to do an income withholding order. It's your obligation to pay your child support. So get a payment in ASAP. Okay?
Yes, Your Honor.
We'll deal with these other issues then on April 28th. And Mr. Eikenberry, if you could review that pro se motion with your client and at least send a notice to Mr. Agnew and the court as to whether any of it or all of it you're going to wish to proceed with on the 28th.
Do that, Your Honor.
Okay? And Mr. Eikenberry, if you would do a journal entry from today.
Yes, Your Honor.
Thank you all. I have an announcement of appearances, please.
Your Honor, Colton Eikenberry is appearing as counsel for Ivy Agnew, and she is not present.
Roger Agnew, appearing pro se, Your Honor.
We are on for a couple of motions. Mr. Agnew has filed a contempt citation, and Miss Ivy Agnew was to appear today on an order to show cause regarding that contempt citation. And then Mr. Eikenberry, you had filed a motion to withdraw as counsel for Ivy Agnew. So go ahead, Mr. Eikenberry, with your explanation.
Thank you, Judge. I received an email from my client indicating she wanted to terminate our attorney-client relationship, and that same day I filed a motion to withdraw. I believe it was somewhere in the neighborhood of 6 or 7 days later, Mr. Agnew filed his motions that are also on the schedule today. I forwarded all of those things to my client at the address that I have in my files for her. I got an email recently from her husband that she had not received those and that email was no longer working. I attempted to again send all of those items to his address for her review. There were multiple emails that I had to forward, Your Honor, and I think possibly one of them that I don't have a record of forwarding to the new one would have been the Zoom link for today. So I do have his email I can provide to the court, so all future communication and notices can go there. My understanding is from the emails and texts received from Mr. Agnew is that mail is difficult being in Bulgaria. It's very expensive, and they would have to actually be at the residence to receive anything. So if they're at work or gone for any reason, it wouldn't get there. So I think email is the best way to communicate with Mr. Tier and Mrs. Agnew. But Judge, I can state, I think that I was directed clearly to not work on the case any longer by my client, and I've taken that seriously. I have forwarded things twice to my client to try to ensure that she gets served. But really, I think my role in this needs to come to an end at the direction of my client.
Mr. Agnew.
Yes, Your Honor. As I stated in the motion, bail is extremely difficult in Bulgaria. It's at times can be costly, at times can be fairly inexpensive. For example, I just sent a birthday card off for the oldest. His birthday is coming up in about 2 weeks now. And it only cost me $3.44. However, that was simply just a letter. Once I add tracking to that, it moved up to about $80. And I'm aware that this is all hearsay, but just to kind of give the court an idea of, estimated expenses. There's ways to serve Miss Agnew documents in the country of Bulgaria, but as I outlined in the motion, extremely difficult and cumbersome, and the fact that neither her and I speak Bulgarian, which is what's required of the documents to be in to use the foreign nationals to serve her. It's very difficult. Miss Agnew can resolve a lot of these issues simply by getting a PO box, which she has stated she refuses to do, which I believe was in the exhibits that I also included in my motion for response. And so that's an issue. In regards to maintaining counsel, I think one of two things needs to happen, Your Honor. Either Mr. Eikenberry needs to not be allowed to withdraw. I understand that they want to end their relationship. However, in the best interest of Miss Agnew and her rights, she needs to have somebody who can represent herself, whether that's her or somebody here stateside who can be served the documents and things like that. In her best interest, it's to maintain somebody on the record, and for the court and for myself, it also maintains our best interest that we have somebody who is stateside who can receive documentations and filings and stay up to date with as little inconvenience as possible. Now, I think the best option at this point is to maintain Mr. Eikenberry on record as her attorney and continue to work through that process that way. However, if Miss Agnew would like to hire another attorney, I don't see why that should be an issue, and that should be granted. However, I think in that regard, Mr. Eckenberry should not be allowed to withdraw until and unless Ms. Agnew has hired another attorney. Again, the biggest thing in this regard is cost effectiveness in regards to filing motions such as the contempt motion that we'll hear later today, or other things, and just as we've noticed today, Ms. Agnew is not here. Having a voice for her is the most important side of things in regards to continuing forward with her rights, and not allowing this to get bogged down in appeals courts and issues like that. And so just based off of those couple of things, I think that we need to maintain a record of counsel one way or shape or the other. The other thing at this point, Mr. Eckenberry has not submitted a final IWO, which is something that the court has ordered him to do as of the last trial date that we had. And as that hasn't been submitted and handled yet, I still think that his work is still unfortunately left to be done. And so at this point, having him withdraw is a bit premature, because then we would have to start back over with the IWO. And I think that would cause issues going forward. That is all, Your Honor.
Did you want to respond for the record, Mr. Eckenberry?
Just only that my client in that same letter advised they would be retaining child support services to finalize the child support in this matter.
Mr. Eckenberry, I'm going to ask your indulgences. I understand your client has asked you to withdraw, but this is a very unique circumstance and a very unique case in that, based on her motion and your advocacy, she was allowed to move to Bulgaria. And I want to make sure we have good communication before we terminate your relationship with her. Okay. The court accepts that she may not have got the link today, so we cannot hold the contempt hearing today. What we need to do is reschedule that. And then when we finish the hearing, but before we get off the link, so once the hearing is over, we'll stop broadcasting. But before we get off the link, Mr. Eckenberry, I'm going to ask you to give those good emails for Bo and Ivy that you have, both to Mr. Agnew and to my administrative assistant, so that we can make sure we keep communication open with Ivy Agnew. At the next hearing, once she is on and present and dealing with this situation, then the court would allow you to withdraw at her request, Mr. Eckenberry, but not until the court establishes good contact with her, okay?
Understood, Your Honor.
So we'll keep you in the case until we can get her on the next Zoom hearing. So Jess, we need to set up another hearing probably in about a week.
Your Honor, one more thing, if I may. I've spoken with Child Support Services, and at this point in time, they have been withdrawing themselves from the case, presumably because she is not stateside using resources like Medicaid and food benefits and SNAP. So,
Mr. Agnew, that's something Ivy will have to explore or Mr. Eckenberry will have to explore.
Understood.
Okay. So Jess, we need to set up a hearing in a week to 10 days.
Might be easier said than done, Judge. Especially with the time change, I assume we need something probably in the morning.
Now we need something, well, something in the do you know if she's working 8 to 5 or what her hours are, Mr. Agnew?
That was one of the other issues, Your Honor, is at this point in time, I don't believe that she is working. She has made comments about going back to housewife status. And one of the issues that we'll have to address during the contempt is if she is working or not. But my understanding is at this point she's not working, but I don't have enough information to say for sure one way or the other.
So 9 o'clock here is 5 PM there. So I would think anything 9, 10, or 11 here would be okay.
Yeah, and Judge, you really don't have anything until the week of March 10th.
Okay. What do you have that week?
You could do a 9 or a 9:30 on the 12th.
Does that work, Mr. Eikenberry?
That's fine, Your Honor.
Okay. Does that work for you, Mr. Agnew?
I see no conflicts at this point, Your Honor.
Okay. Do you know what time the boys come home from school?
Generally speaking, about 10 a.m. our time, if I do an afternoon call, I attempt to do an afternoon call around 10 a.m. So they're at home at that point, but I don't know exactly what time they're getting home.
Let's go with the 9:30, Jess. 9:30 our time, which would be 5:30 their time. Mr. Eikenberry, will you do a journal entry from this morning, moving it to March 12th at 9:30 a.m. our time, 5:30 p.m. Bulgaria time?
I can do that, Your Honor.
Okay. Okay, that concludes this hearing. So Jess, we can jump off of.
Your Honor, Ivy Agnew is appearing in person via Zoom, and Colton Eikenberry of Hayes also via Zoom.
Your Honor, Roger Agnew appearing pro se via Zoom.
We're on for an order to show cause at the end of the last hearing on February 20th. We discussed that we would take up 3 things this morning, possibly a 4th one with Mr. Eikenberry's motion. If you're still pursuing that, Mr. Eikenberry.
Your Honor, and if the court will allow, I would like to address that one first.
Go ahead, Mr. Eikenberry.
Thank you, Your Honor. I was directed via an email by Ms. Agnew that she no longer wished to have me as her counsel and to stop all services. So I have followed that request, Your Honor, and I did file a motion to withdraw. I sent the notice of intent to withdraw, wherein she would need to either be prepared for any motions going forward or retain other counsel. And we have had absolutely no communication since that time. So I am of the belief that she wishes for that to happen as well.
Ms. Agnew.
Yes. Yeah, I agree. Yeah.
Okay, you understand you need to have counsel here in Kansas. This is a very unique situation where you have moved to Bulgaria, but you
Mhm.
need to have counsel here. Your case is still in Kansas. Your case is still here.
Okay.
And you need to have counsel here that Mr. Agnew can contact if he's having any issues regarding you.
Okay.
Do
In
you
that
have-
case,
Do you have another attorney?
I don't have another one lined up currently. So if that's the case, then yes, we can retain until we are able to find other representation, if that's what needs to happen.
Yeah, you need to have counsel here, local.
Mhm.
Okay? I think you understand this is a very unique situation where
Yes.
you moved with the boys to Bulgaria,
Mhm.
okay?
Yes.
But you need to have local counsel.
Okay.
So if that's not Mr. Eikenberry, you need to retain someone else,
Okay.
okay? Now, do you want to talk with Mr. Eikenberry and see if it's going to be him or if you're going to retain different counsel? Would the 2 of you like to go in a breakout room for a minute and talk?
Maybe just for a moment to get on the same page.
Okay. Sandy, if you can put Mr. Eikenberry and Miss Ivy in a breakout room. Okay, Miss Agnew, did you have sufficient time to speak with Mr. Eikenberry in the breakout room?
Yes, yes. We agreed that he, is no longer going to have interest in representing us, and that we won't be able to move forward with that. So we are gonna see if we can ask for a continuance so I can find alternative legal representation, and get somebody else here for my legal representation for the case.
Mr. Eikenberry.
Correct, Your Honor.
Okay. And Mr. Eikenberry, you understand that I'm going to keep you in until she has new counsel to replace you.
That's fine, Your Honor, but related to all of the other issues that are here today, at Ms. Agnew's direction, I have spent no time reviewing any of it and will be absolutely unprepared to make any arguments on her behalf today. So that is something that will need to happen with new counsel. So I would agree with her that we need to continue this so she can get a lawyer.
Mr. Agnew.
Yes, Your Honor. Prior to any sort of notification from Mr. Eikenberry about his intent to withdraw, there had been conversations from me to Mr. Eikenberry about his client's inability to follow the current orders, and that had been arisen early in January. Mr. Eikenberry, for whatever reason, did not decide to take part in conversations with that. And again, the key being that.
Mr. Eikenberry, I don't mean to cut you off, but we're not getting into the heart of it right now. The issue
Sure.
right now is simply her changing counsel.
Okay.
Which
I have.
He has a right to do.
Sure. I agree. My only argument is that in terms of the continuance was that ill-advised at this point. It's already been over a month since the original hearing date. And then, like I said, Mr. Eikenberry had already been informed of the issues at hand prior to asking to remove himself from counsel. So that would be my only comment. And I don't have a problem with her retaining new counsel or changing counsel at all. But in terms of everything else, I believe at this point it should continue forward. Mr. Eikenberry was well aware of all that information.
Well, Mr. Eikenberry, you'll remain in until new counsel enters their appearance in this matter. Okay. We will continue the contempt citation till she can secure new counsel. Okay. And as far as the video contact, has that been occurring, Mr. Agnew?
With the time change, there's been some issues on my part of making sure that I'm awake at the appropriate time. Currently, the time difference, as I stated last time, was 8 hours. It's currently 7 hours, and so it's a little bit later in the night. So I missed last night's, and I missed a couple other ones. They are happening at times, yes.
Okay. And Miss Agnew, have you been having any issues with the video visitations?
No, he's able to call 7 days a week. He does at least 4. Sometimes it's multiple calls a day. On rare occasions, we've not been able to do a call. But overall, every single week, he's had at least 4 calls, sometimes multiple calls a day.
Excellent. And are the boys adjusting well?
Yeah, they're adjusting really well. They're doing really, really well.
Okay. You understand Mr. Eikenberry is going to stay in, but only until you have new counsel.
Yes.
The court doesn't expect him to be working on your case at all,
No.
but he is your counsel of record so that you have counsel here in Kansas.
Yes.
Till you replace him with counsel. As soon as you have new counsel, Mr. Eikenberry is allowed to withdraw.
Understood.
I need to have a local in Kansas attorney representing you in this matter, okay?
Yes.
That was one of the conditions we talked about when the court agreed for you to move with
Okay.
Bulgaria. Okay.
Yeah.
Okay. Anything else for the record then today, Mr. Eikenberry,
No, Your Honor.
Mr. Agnew?
No, Your Honor.
Okay, Miss Ivy Agnew.
Mm.
And are you still going by Agnew?
Yes, for now. Yeah, I am.
What I'd like to do then is set up another hearing. I'll give you, if we set it down 30 days, that should give you time to obtain new counsel and get them up to speed. So Sandy, if we could find another hearing about this same time slot because of the time changes between here and Bulgaria, about a month down the road.
Okay, a month down the road, and so give me time. I mean, you wanting it in the morning like this again, probably?
Yeah, because of the time change, I think it's about a 7-hour difference.
Okay.
It'll be 8 at that point, Your Honor.
Okay, 8-hour difference, but this time slot seems to work well.
Okay. All right, so I can do something April 15th, April 17th, both of those have morning times.
Your Honor, there's a CLE seminar on the 15th that I would like to attend, but the 17th is available.
Okay. You guys can make that work?
That work, Mr. Agnew?
17th is available for me, Your Honor.
Okay, let's do April 17th at 9 our time, or is it, yeah, 9:30 our time, 9 o'clock, what works? I don't care. Any preference?
9:30 is better for me.
9:30, okay. April 17th, 9:30, we're just gonna consider this a status, is that correct, Judge Reese?
Well, it'll be a status and scheduling conference.
Okay.
Hopefully, new counsel on board, and then we can schedule
Okay.
the hearing after that.
Status / scheduling conference. All right, April 17th, 9:30 our time. I assume someone will do a journal entry?
Can I impose on you, Mr. Eikenberry?
I can do that, Your Honor.
Do a
Okay.
journal entry?
All right, thank you.
Thanks, Sandy.
Okay, we'll get back together again on April 17th. Keep those video visitations rolling. Keep helping the boys adjust to their situation and secure new counsel, Ms. Agnew.
I will do that.
Okay. Thank you all.
Thank you, Your Honor.
You, Judge.